Hi, everyone. I'm Steve Herrick. I'm Executive Director at Cooper Square Committee. So welcome. This is our first online workshop for our senior program, and it's about the importance of preparing life documents. These include Advanced Health Directive or Health Proxy, Power of Attorney, and Last Will and Testament. These documents take on even greater urgency now in the midst of the COVID-19 epidemic, which has tragically taken the lives of over 22,000 New York City residents, the vast majority of whom are senior citizens. Our senior program has run a series of workshops over the last few years for Lower East Side residents, and it's part of our Neighborhood North program. Carmen Perez, who you may have just seen, is our program director, and she'll be providing simultaneous translation on a separate channel for people who speak Spanish. Our email and Facebook invites provided the sign-in information for English and Spanish-speaking viewers. And today's workshop is going to be both here and on YouTube, and it will be made available at some point afterwards for people to watch the recording. There's going to be a question and answer period at the end, so you should type your questions into the chat box, and we'll have Peter answer them. So our guest speaker today is Peter Kempner, and he's an expert on these topics. He's the legal director and elderly project director at Volunteers of Legal Service, also known as VOLS. He's been practicing law for 19 years in their HIV unit from 2001 until 2011. He helped found the Veterans Justice Project. In April 2015, he became the director of the Veterans Justice Project and the deputy director of the housing unit at Brooklyn Legal Services. He's also an adjunct professor at New York Law School, and he's been with VOLS since 2018. And I'm pleased to introduce Peter Kempner.
Thanks so much, Steve, and thanks everybody for having me today. So like Steve mentioned, I'm here to talk about the importance of life planning documents, is how we put it. If you overheard us earlier, sometimes people think of these as end-of-life documents, but really there's a lot of documents that are important during your lifetime, and we don't want to focus on end of life. We want to focus on making sure that during people's lifetime, they're able to live in the community as long as possible, that their caregivers are empowered to act on their behalf, and that their wishes are clear, both during their lifetime and for after they pass away. And so, like Steve mentioned, we prepare a whole set of documents for our clients to deal with different aspects of both possible incapacity and also end of life. And so the documents that we do are last wills and testament, powers of attorney, healthcare proxies, living wills, and then also controls of remain form. Our project serves people who are 60 years and over and live in New York City, and people who have low income and limited resources. And at the end, I will talk a little bit about how to access our services for yourself or other people you know who may be interested in getting our help. So, like I was saying before, when we talk about life planning documents, we split them into two categories. First are documents that are important during your lifetime, and the second are the documents that are important after you pass away. And so when we talk about documents that are important during your lifetime, we do a durable power of attorney, a healthcare proxy, and a living will. And for documents that are important after you pass away, we do a last will and testament, and then the appointment of agent to control disposition of remains form, which I know is a mouthful. We'll tend to call it control of remains form. So let's first talk about the fact that some of these documents require you to appoint somebody as your agent. And as we go through these one by one, you'll see what I'm talking about and what roles these people play. But just be aware that in order to get a lot of these things done, you need to have somebody to be able to step into your shoes. and act as your agent for you. And unfortunately, with some of them, if you don't have an agent, it's a barrier to completing these forms. But other documents, you don't necessarily need an agent in order to complete the forms. And so we'll go through those one by one as we talk about those documents. So let's start by talking about the durable power of attorney. And people come to us and oftentimes they'll say, well, I want to get my will done. And I say to them, look, let's take a step back. Let's talk about all the various documents that you might be interested in having done for you. And, we throw at them this, that, and the other thing, and it's a lot. And sometimes people will say to me, if you recommend having one document and only one document, what would it be? And I always say it's the durable power of attorney. This is perhaps the most important thing for people to have in place because it really is very versatile and it protects you in ways that some of the other documents can't. And so let's talk about what a durable power of attorney is. First of all, it's a very powerful document that gives another person the ability to do property, financial, and other legal transactions on your behalf. In the document, when you're filling it out, you're known as the principal, and you're appointing an agent. So the person that you're appointing is your agent under your power of attorney. A lot of people will say, well, I'm somebody's power of attorney. No, you're not. You're actually their agent under a power of attorney. And so you're giving
Hi, everybody. Sorry I'm late.
Hi.
Jasmine.
Hi, Jasmine. So you're giving somebody the ability to step into your shoes and do these things for you. And so that includes things that you would expect, something like dealing with the bank, writing checks, paying bills. But it also gives them the ability to do other things. For a lot of our clients, one of the most important things is getting access to benefits. And so, if you are a recipient of public assistance or food stamps or SCREE benefits or DRE benefits, all of those benefits require you to do annual recertifications to deal with the agency on an ongoing basis that is in charge of those benefits. And if you fail to do your recertification with Section 8 or food stamps or whatever it is, then you could lose those benefits. It also allows somebody to apply for benefits on your behalf. And so if you weren't receiving Social Security before or getting any of these other benefits beforehand, it allows your agent to apply for those benefits on your behalf. And so when you think about it, being able to pay the rent or the mortgage on your apartment, being able to apply for benefits that will allow you to pay your rent, these are all things that allow people to remain in their homes and remain in the community. Because if you lose the ability to do those on your own, and there's nobody who is empowered to do it for you, then it could really be disastrous and lead to homelessness. And so it's really important in that way. Bills will go unpaid, leases will remain unsigned, you could lose your benefits. And then what happens? Well, if you don't have a power of attorney in place, then your loved ones may be forced to file what's called an Article 81 guardianship. And so that's where you make an application to the court to say this person is incapacitated, they can't take care of their business on their own anymore, and somebody needs to be appointed to take over their affairs for them. The Article 81 guardianship process, like most court processes, is a lengthy one. It's very time consuming. If the family member or loved one who's trying to seek it lives out of state, they might be forced to hire an attorney to do this process for them. Or if they work full time and they can't get off the time to work from work to make the court appearances, they may also have to hire an attorney, and that's going to be costly. In addition, when you make this application to the court for an Article 81 guardianship, the court needs to make sure that the person who you're seeking a guardianship over really is incapacitated. They're not just going to take your word for it. A guardianship strips you of your legal autonomy. And so they're going to do an investigation. And that often means getting adult protective services involved. They're going to do home visits. They're going to do interviews. They're going to interview doctors and neighbors and family members and yourself. And that's an intrusive thing where you have the court and government agencies, prying into your life. And so because it's costly, time consuming, and intrusive, it's something that could be avoided by preparing a power of attorney in advance. So these business matters are being taken care of for you when you can't do it yourself. One thing to note about just kind of the language of the durable power of attorney, it's durable because it outlasts capacity. It's not because it's printed on cardstock and you can't rip it. It's durable because you do it when you have capacity, and then if you lose capacity, it remains in effect. That's why it's a durable power of attorney. And I said before, it's a powerful document. It can be used as a tool of financial exploitation. And we see that happen with seniors sometimes. Because somebody will have access to your bank account, they could take advantage of that. And so in naming an agent under a power of attorney, you want to make sure that you're naming somebody that you really trust to play that role for you. Because, especially if you lose capacity, you won't be able to look over their shoulder and police them if something goes wrong. But again, probably the most important document that we could prepare for a client. Next, I want to turn to the healthcare proxy. And so the healthcare proxy, it's similar to a power of attorney. And in some states, they actually call it a healthcare power of attorney. But in New York, we call it a healthcare proxy. And again, you're filling out the form, you're the principal. You're naming another person, again, your agent. And this person, instead of making financial decisions for you, they make medical decisions for you. The big difference between the power of attorney and the healthcare proxy in this respect, though, is that a power of attorney is effective immediately upon signing. It doesn't wait for you to lose capacity in order for it to become effective. But a healthcare proxy doesn't kick into place until you lose capacity yourself. And so, for instance, I'm my wife's healthcare proxy. And so if I was to accompany her to a doctor's appointment and the doctor says, well, are we choosing treatment A or are we choosing treatment B? They're not going to turn to me as the healthcare proxy, as the agent under the healthcare proxy to make that decision. No, she's sitting right here. She's able to make her own decisions for her. This doesn't, just because she's done this form, it doesn't take away her ability to make decisions for herself. And some people have those fears that if they do this form, then they lose that ability to make their own decisions. You don't lose that ability to make your own decisions. What you do is have somebody who step into your shoes in the event that you can't make those decisions for yourself. And it's only at that point where it becomes effective. And so, unlike the power of attorney, there's actually a backup plan in the law if you don't have a healthcare proxy. And that's something called the New York Family Healthcare Decisions Act. So under the Healthcare Decisions Act, what it says is if you don't have a healthcare proxy, we're going to set out a family tree of who's able to make healthcare decisions for you if you can't make those yourself. And it's similar to what you would expect in the family tree as far as who's closest to someone. The first person named is your spouse, then it's your adult children, then it's your parents. And, it depends on whether you have those people in your life, if they're still alive or if you ever had them, because obviously some people don't get married or have children. But if you have a living spouse, they're the first in line. If you don't have a living spouse, then it's your adult children. If you don't have adult children or a living spouse, it's your parents. If you don't have living parents or the others, it's your siblings. And it goes down through the family tree in making a decision about who's in charge of your healthcare choices if you haven't done a healthcare proxy. And that works for some people who have close family who they trust. But for other people, that really doesn't work, right? For people who don't have a spouse or children, and maybe their closest living relative is a sibling who they haven't spoken with years, or they're estranged from, or they don't get along from. And maybe that's the last person you want to be able to make life or death decisions for you. And so for those people, it's particularly important to have a healthcare proxy in place because you get to override that family tree and pick who you trust the most, who you've had those conversations about, end of life philosophy with, to be able to play that role. The other thing is, even if you are picking your spouse or your adult children in your healthcare proxy, it's still worth having, because what we advise all of our clients is to make sure that they have their healthcare proxy on file with every medical provider that they see. And that way, if something happens and they need to get in touch with, the agent and you're effectively your emergency contact, then they're able to do so quickly. If something happens to you, you don't want the doctors to try to have to figure out, oh, do they have a spouse? Do they have kids? What's their number? How do I reach them? No, you want them to be able to look at one piece of paper that's in your file that clearly says, this is the person in charge. This is who you should contact if anything should happen to me. So it's a very effective tool in that sense, as well as being able to override the law that would dictate who makes your decisions for you if you can't make those yourself. The next document that we prepare for clients is the living will. And so a living will is different from these other documents in that you're not naming a person in the living will, you're laying out what your wishes are. And so there's no agent, there's nobody who you're naming. What you're doing is you're saying what you want or what you don't want at, if you're ever in a situation where you have a terminal illness. And so it's things like whether or not you want intubation, whether or not you want cardiac resuscitation, whether or not you want palliative care, whether or not you want antibiotics. These are the things that are laid out in the living will. And look, some people feel very strongly that if they find themselves in a terminal condition, that they don't want to spend their last days hooked up to a bunch of machines. Other people feel very strongly that they want to fight for every second that they have on this earth, and they want the doctors to pull out all the stops. And those are both two really legitimate points of view. And you want to be able to make sure that you're able to express those things, depending on where you fall to your healthcare provider in the event that you can't communicate yourself to your healthcare provider. And so if you don't give clear written directions, then your doctor actually has a responsibility to keep you alive by any means necessary. And for some folks, certain things they want and other things they don't want. And it's actually an opportunity to put things that are important to you. For instance, once we had a client who felt very, very strongly about amputation. She, no matter what, didn't want any limbs or digits amputated. And I actually was a little troubled by the conversation. So I said to her, look, if it's like your leg or your life, you would choose your leg over your life. You would choose to put your life at risk to not amputate a leg. And she said, yes, I don't want to live like that. I would rather pass away than live like that. And so that's what she wanted. And so we communicated that in her living will. On a lighter note, my wife actually once was watching one of these daytime talk shows. And there was a woman who was on the daytime talk show who had been in a coma for like 5 years. And she was at one of these care facilities. And as a matter of course, they gave all the patients a flu shot every year, right before flu season, to make sure that people were not getting flu and were healthy. And this woman got a flu shot after being in coma for 5 years. And all of a sudden she woke up from her coma. And so we could debate all day long about whether that was causation or coincidence, who knows? But my wife has put in her living will that she's going to get a flu shot before I pull the plug. And I know, as her agent under her healthcare proxy, that I'm going to make sure she gets that flu shot before we end any life-sustaining treatment. Otherwise, she'll haunt me for the rest of my life. So this is an opportunity for you to express things like that if they are important to you in your living will. It also could act as instruction for your agent under a healthcare proxy You could have one without the other. You could have a healthcare proxy and not have a living will, and vice versa. Some people sadly don't have somebody who they feel comfortable stepping into their shoes and making healthcare decisions. And so they might not have the healthcare proxy, but they could have a living will. But if somebody has both, then your proxy, your agent under the proxy, could look to the living will for what you want. They're not necessarily bound by it, but it could give them guidance. And we recommend to all of our clients to make sure to have conversations with people before they name them in any documents. We want to make sure that anybody you're naming as an agent is ready, willing, and able to do that on your behalf. Steve, for instance, and I get along great, but we barely know each other. If all of a sudden he got a phone call from the hospital and found out that I named him as my agent under the healthcare proxy, or I named him as my agent under a power of attorney, he might say, you know what, Pete's a nice guy, but I'm not taking on that responsibility for him. I'm not doing that. And so you don't want to find yourself in a situation where somebody doesn't want to do something, that they're not willing to act for you. So you want to have those conversations in advance. And you want to have a conversation, particularly with respect to healthcare proxy, about what you think about end of life, whether you want, the interventions or not. But we know that these are hard conversations to have. I've spoken to a number of clients who I said, well, did you talk to your son? Did you talk to your doctor that you don't want these interventions at the end of life? And the client will say, yeah, well, I tried, but they put their fingers in their ears and they said, no, Dad, you're never going to die. I don't want to have this conversation. I can't. No, stop. And that's common, right? So this could, act as a guidepost if something was to happen for your agent to help guide them in decision making for you when you can't make those decisions yourself. So those are the set of documents that we do for folks, during their lifetime. And really the during your lifetime is the important piece to me. We'll talk about a will and a last will and testament in a few minutes. That's what happens to your stuff after you pass away. I'm concerned with making sure that during your lifetime, you're able to stay in your apartment, you're able to stay in the community, you're able to get the care you need, you're able to get the benefits to which you're entitled to, and you're able to make sure that the people you love and trust the most are empowered to act on your behalf. And so, that's why we call the presentation life planning documents instead of end of life planning documents, because we're really planning for life as well. All right, so now I'm going to turn the page and talk about the documents that are important for after you pass away. And the first thing that comes to mind, and this is the most commonly prepared document, is the last will and testament. And so last will and testament, you're saying who you would like to inherit your property. So whether that is your personal possessions, the contents of your apartment, your books and your record collection and your clothes and the like, but also any money that you may have that hasn't been otherwise designated, any real estate that you own, your apartment or your house or whatever it is, a car, any kind of property. You get to say what happens to that property after you die. And so, and that property, all of those things that you own are called your estate. And so, think about it, I own a bunch of stuff. During my lifetime, when I'm able to, I make decisions about what happens to my stuff, right? I could buy, I could sell, I could give it away. I decide, I'm in charge. After I pass away, my stuff is still here, but now it doesn't have the brain. It doesn't have that person in charge anymore to do that decision making. And so that now it becomes my estate. And so somebody needs to be in charge of the decision making over my estate. And so if you have a will, then you are able to name somebody who's in charge of that decision making. That person is called your executor, and they're going to take care of any debts that your estate has, any taxes they have to pay, and then they'll distribute your estate to the people that you've chosen in your will to have it distributed to. If you don't have a will, on the other hand, then it's a very, very different process. Just thinking about the language of last will and testament for a second, you know, testament, when you think about that word, it's got the same root as testify. When you testify, you speak your mind, right? You say what's going on in your head. And so in your testament, in your last will and testament, that's where you've spoken. That's where you've said where you want your property to go, who you want to be in charge of it. If you die without a will, the law that kicks into place is called the intestacy statute. And so again, the same root, intestacy as far as testament, but this is, you know, flipping it on its head. When you've died intestate, you failed to have spoken. And so that you haven't given that guidance, you haven't appointed somebody to be in charge. And so when you die intestate, the intestacy statute kicks in, and the law determines who gets to be put in charge of your estate, who gets to inherit your property. And it follows a similar family tree that we talked about before: spouses, children, parents, siblings, nieces, nephews, cousins, aunts, and uncles. All those folks are in the mix. And so you have a lot less control, right, over what happens at that point. When you pass away with a will, you go to the Surrogates Court to probate the will. If you die without a will, you actually still go to the Surrogates Court, but the process is not called probate. Instead, it's called administration. And instead of an executor being appointed, the executor who named in your will, they now appoint somebody who's called an administrator, who's in charge of administration of your estate. And so there's a difference there as well. Administration also could potentially be a slower process as well, because they have to track down your family members, they have to notify them, figure out the family tree, who is eligible for inheritance, who's not, who's alive, who's dead, do they have kids or not, and all of those things. And so that's a longer process that actually is handled by the public administrator's office, which is another government agency. So again, there's intrusion from a government agency into your affairs that could be avoided for the most part if you had a will and had clearly expressed your wishes in advance. One of the things, and regardless of whether you're doing probate or administration, it's still a court process. And the reality is court processes are slow. And also, again, if you have your executor or your next of kin are living out of state, they may have to hire an attorney to make those appearances for you. Again, when you file a will, it's actually public record, and so people could look that up. And so to be aware of all of those things. And so we try to talk to people about, is there a way to avoid the probate process? Is there a way to avoid administration by setting up your affairs in such a way where your property passes outside of your estate? And let me explain what that means. And there's certain easy examples. And so let's take an easy example first. Think about your retirement accounts. If you have a 401k or a 403b or an IRA or a Roth or whatever it is, on all those kind of financial accounts, you're able to name a beneficiary, right? And so when you pass away, your beneficiary simply needs to go to that financial institution, show proof that you passed away, your death certificate, proof of their own identification, and fill out some paperwork with the bank or the financial institution, and they'll actually be able to access that money without ever having to go to court. So it's passing outside of the estate. It's not going through the probate or administration process. It's on the side, which is a good thing. It's faster, it's easier, it's less time consuming. And you could do that also for your regular bank accounts as well. It doesn't have to be a retirement account or an IRA or anything like that. You could do that on your regular checking and savings account. You simply go to the bank and you say, I want to make a designation that the account is payable or transferable upon death to this other person. They won't be able to access your account during your lifetime. They're not going to be able to muddle in your affairs. That's what a power of attorney is for. You do a power of attorney if you want somebody to be able to get into your affairs and get into your bank account. This only kicks into effect after you die. But that way, whoever you're naming as payable or transferable upon death to shows their, proof of your death, proof of their identification, filling out the paperwork, and they're able to access that money right away without having to go to the court process. And so, obviously beyond the time and cost aspects, another advantage is, for a lot of people, especially a lot of our clients, that little bit that's left in their bank account after they pass away, that's what's going to help the family pay for your final resting. So whether it's cremation or burial or whatever it is you wish, those things are expensive, and families have to bear that cost. And a lot of the times, particularly our senior clients will say, well, I want, this amount in my bank account to pay those things, so my kids and grandkids and whoever don't have to pay for it out of pocket. But if they're not able to access that money, they're going to have to pay out of pocket and then go to court and try to access that funds later in order to get reimbursed for those final expenses. And so this is a shortcut, again, for those folks to be able to access this money faster, to pay for those final expenses, to avoid going to court. And frankly, for a lot of people who are low income and have limited resources, if people are able to access your bank accounts, and there's nobody who's fighting over your personal property, then maybe we never have to go to court to probate the estate or submit the estate for administration. And so, that's a good thing. There are other more complicated ways to avoid probate and administration by setting up trusts and other things along those lines. We don't do that work because our clients have limited income and limited resources. That's the work of private attorneys, not us nonprofit attorneys. So I'm not going to get into those details, but I will let you know that there are other avenues available there as well. And so, just a quick note about these designation of beneficiaries on accounts, and this really actually applies to all of these documents. What we tell folks is you want to check every couple of years. People say, well, do I need to do a new will every year or 2 years or 10 years or whatever it is? I did a will 20 years ago. Is it okay still? What we recommend is take a look every couple of years. Make sure that everybody you've named on your accounts, make sure everybody you've named in all your documents are still alive and you still like them. Because both of those things change, right? People are often naming people who are their peers. So if I'm 80 and I'm naming other 80-year-olds, there's the likelihood that somebody's going to, expire first. So you want to make sure they're still around. And then there's other times where people fall out of favor and relationships change. And we want to make sure that you still have that trusted relationship with somebody who's named in your documents, who's named on your accounts. And so check them every couple of years. If everything's fine, then you don't have to change them. They could be good for decades. All right. So the last document I want to talk about is the appointment of agent to control disposition of remains. Mouthful, let's just call it the control of remains form. This is a document where you're naming a person to handle what happens to your body after you pass away and to carry out your wishes as well. And so in it, you'll say, I want to be cremated. I want to be buried. I want to have my ashes, thrown in the Atlantic Ocean. I want to have my whole body donated to science. Whatever it is, you're able to lay out those wishes in your control of remains form, and you name somebody to be in charge, your agent, just like the other documents, of carrying out those wishes for you. If you ever have any kind of prepaid funeral agreement, if you own a burial plot, anything like that, you want to put that in your document as well. Just a couple things, right? First of all, you've passed away. Let's assume people are a little distraught, right? They're going to say, I know Pete he's talked about having a prepaid funeral agreement, but I don't know if it's with funeral home A or funeral home B. And so they're rifling through your documents trying to find it. No, we don't want to put people in that situation after you pass away. We want to be able to hand it to them on a silver platter. So they have all that information at their fingertips. Your wishes are clear. And then as far as thinking about empowering somebody to claim your remains, look, if a spouse shows up to say, look, my husband, my wife passed away, please turn over the remains to me so I could have a funeral or a cremation or whatever it is, they're not going to give that person a hard time if they're the spouse or if they're the adult children or if they're the parent. But once you start getting further away from those relationships, it actually may become problematic, right? If somebody doesn't have those close relations and a friend shows up to the county medical examiner's office or the morgue or the hospital and say, I want to claim Pete's body, they're going to say, and who are you? And I'm a close friend. And they're going to say, well, we can't release a body to a close friend. What gives you the authority to claim this body on that person's behalf? Well, what gives me the authority would be the control of remains form. There are ways to get around it, similar to the other laws that we talked about. Public health law creates a list and who's in charge. And if everybody else is either not claiming the body or refuses, then you can, as a friend, write a letter and do this, that, and jump through all these hoops in order to claim a body. But again, who wants to put somebody through that? Who wants to have them jump through the hoops? We want to make people's lives easier at that point after you've passed away. And so this lays out your wishes, empowers your agent to be able to carry out your wishes for you, and makes things a lot easier. And it's a fairly simple document to complete. I know a lot of people say, well, why don't I just put that in my will? But the reality about the will is the will's just a piece of paper until the court says it's otherwise, right? How do we know it's really Pete's will? Just because I show up to a funeral home and say, here's Pete's will, it says I'm in charge, let me make all these decisions and claim his body. Who's to know that that's not a fraudulent will? Who's to know I didn't just go to my office and type it up right now? The Surrogates Court makes that determination. Was it really Pete's will? Was it properly executed? Does it follow the rules? And that process for the court to issue letters of either administration or testamentary letters takes weeks. If there's somebody who's contesting the will, it could take months or years. We don't want weeks or months or years before we could claim somebody's body and lay them to rest. We want that to be able to happen right away. And so that's why we separate out the issue of control of remains from the issue of personal belongings and real estate and all of those issues, so we could deal with the burial or cremation or whatever it is first, then we'll deal with the estate later. And so that's, New York law creates this form, it has utility, and that's, one of the reasons or a couple of the reasons why it's really worth having as a separate document from your will. So those are the documents that we prepare for folks. Let me just give you a quick notice about how to access our services. You can go to our website. Both pages are up there, valsprobono.org for folks on the phone. There's a list of our projects. Click on the elderly project. If you're a veteran, you could click on our veterans project. Our forms are available. Our intake forms are available on our website to download and fill out and send back to us. Right now, we're working all remotely, and we will be for at least the foreseeable future. You used to do pre-COVID clinics at a dozen senior centers around Manhattan and at the VA hospital on a regular basis. Now we're not doing those anymore, and so we want to make sure that clients are still able to access us and our services while we're all remote. As far as executing the documents, there remains some challenges there as well, because these documents require witnesses and notaries. And just a quick note about that, the governor has actually put in temporary laws in place that allow for virtual notarization and virtual witnessing of these documents. So that could all be accomplished over, Zoom or, Google Hangout or FaceTime or whatever it is, so long as somebody has the ability to see you in real time signing your documents and you're able to transmit those documents to the other person. We recognize that a lot of clients that we work with either don't have access to technology or aren't comfortable enough with the technology to be able to use it for something like this. And so what we're doing for our clients is we're creating a set of very specific step-by-step directions about how to self-execute documents during the crisis when they can't meet face-to-face with an attorney. I know a lot of people are scared, and I know a lot of people are worried, and they want to make sure that they have the right plans in place, and we don't want them to not be able to do this during the crisis. And so we've created tools for them to be able to self-execute their documents, until the point at which we have volunteer attorneys that are able to meet with them face-to-face. And we clearly just don't know when that's going to happen yet. And so some people are choosing to wait. I would encourage people not to wait, to get it done to the best of our ability now. And then we could always revisit it later and redo it in a post-COVID world where we're able to sit down together at a table and sign in front of each other. So that's what we do. That's our work, and I'm happy to take any questions from anybody for our remaining time.
Okay, so we've got some questions from the chat, and so if anyone has any questions that they haven't already asked in the chat, you can type it into the chat and I'll read them out. And after that, we'll also unmute people so that people who haven't been able to use the chat or people who are calling in from phone can ask those questions. So first question is, if these documents such as power of attorney, health proxy, and living will, if someone can find them online, and if they can fill them out on their own, or should they retain a lawyer to help prepare them?
All right, so that's a complicated question, and I'm going to hedge my bets a little bit. So there, and I'm sure we've all heard of them. There's, online services like LegalZoom.com, and I'm not endorsing any of these, that you could do it online. One thing always jumps in my head. One of these places, it's called For the People, I think, and they're like, we'll do your documents for $50. They're co-located on 14th Street. I think it's between 8th and 9th Avenues with a podiatrist. It's like, I don't know if I want to get my will while other people are, getting their feet treated. It's just an odd pairing to me. So you don't need to have a lawyer. There are ways to get this online. Or other places. There's, you could actually go to some stationery stores and they have forms, particularly the power of attorney forms available that you can just buy for a few bucks. But I will say this, and this is not me shilling for attorneys. I've been an attorney for 19 years. I've never charged a client a penny in those 2 decades. So I'm not about making sure lawyers have work. You just want to be careful because if you do it wrong, you sometimes can't fix it, right? And so obviously if you do the will wrong, if you don't properly execute it, and that's discovered after you pass away, there's no resurrecting you to do a new will. But also if you do the power of attorney wrong, and you are in a vegetative state and your agent's trying to use it and the bank says, no, it's not filled out properly, then it's too late. And they're gonna have to go and do an Article 81 guardianship anyway. And so all the things that you were trying to avoid don't get accomplished. That's easy for me to say as a nonprofit lawyer whose clients get my services and my volunteer attorney services for free. But if you don't qualify for our services, that's harder. Because then you have to pay out of pocket. So I would just caution people to be careful. Particularly with the power of attorney, banks are real sticklers with the power of attorney. They want to make sure that every T is crossed and every I is dotted, because they know that this could be used as a tool of financial exploitation, and they don't want to be liable for it. So they, when you get it, they send it to their legal department and they vet it and they, really check every line. So just be careful.
Gotcha. Our next question is from someone who lives in a Mitchell Llama co-op, and I'll read it. What are the magic words to ensure that my co-op does not have a hassle when I die? Ownership of my apartment reverts to the corporation upon my demise. I'm issued shares, and there is a fiction that I and we are owners, but in fact we pay a form of rent.
Right. So with Mitchell Llamas and other, HDFC co-ops, and there's, we got an alphabet soup of different kinds of subsidized housing in New York City. And with this, kind of limited equity co-ops, they're all limited equity co-ops where you're not paying market. You bought your unit for $10,000 and you sell it for $10,000, right? You are both an owner of the shares, but you're also a tenant at the same time, right? And you're not paying rent, but it feels like rent. It's maintenance, and so it depends on what you're trying to accomplish, right? If you want a family member to take over, then it's not enough to just put in your will, I want my shares to go to X person. That person needs to have independent succession rights to the apartment in addition to being entitled to the shares. And so we've seen it play out both ways, where somebody clearly has succession rights. They were on the household composition for the co-op. They lived in the unit. They are, within the family, membership that qualifies them for succession rights. But then the will, or frankly, the lack of the will more often, will mean that the shares revert to somebody else completely. And then so the person with succession rights is now not an owner and they can't take over. And then vice versa happens too, where you in a will, you say, I'm leaving my shares to this person. Or you die without a will and the shares automatically, become part of your estate and they go to that person, the rights to it go to that person, but they don't have succession rights. And so they can't take over the apartment either. So you need to have both of those things, and different developments have different rules too, right? Like I'm kind of boiling it down to the simplest kind of common denominator. But there's some units that are just for seniors, right? And somebody doesn't age qualify, and so you have to check the bylaws when drafting, but you also need to think about, will the person have succession rights as well as the right to inherit the shares? And so there, unfortunately, to go back to your question, there's no magic words. The magic words depends on which magic act you're in.
And that person also wanted to ask if you could speak a little bit about filing with Surrogates Court. They say they were cut out because a friend did not. I'm guessing because a friend did not file with Surrogates Court.
Well, so to probate a will, you need to file it with the Surrogates Court. And certainly there's a lot of wills that never get filed with the Surrogates Court. So I obviously don't know the specific facts of that circumstance. So it's hard to comment on that. But like I said before, will's a piece of paper, and people could choose to ignore that piece of paper. It's harder with something like property ownership, where co-op shares or deeds need to be transferred, and you can't just do that without legal authority. You can't just show up and say, transfer those shares over to me, or transfer the deed over to me. You need force of law behind that. But if it's things like, personal property in an apartment, somebody could go into an apartment and take that stuff, even though the will says something different. And so if you believe you're a beneficiary of a will that was never submitted for probate, you could submit it for probate. The problem with that sometimes becomes that you have to submit the original will. They won't take a copy. The court requires the original document. And for obvious reasons, like if I did my original will and then I've changed my mind and tear it up and do a new will, but happen to have made a copy of that first one and somebody has a copy out there, how does the court know that I didn't tear up my original will? So that's why they want to see the original. There's certain exceptions for that. For instance, if you died in a fire and your will burned with you, then they'll take a copy. But really, absent kind of those extraordinary circumstances, it has to be the original document, and you might not have that. And you just don't know, whether that was revoked, and sometimes you don't even have the copy, and so maybe somebody said, well, I put you in my will, but they didn't. So it really all depends on the circumstances.
All right, I've got another question. How long does the will process take from start to finish?
Again, and I'm sorry I keep on answering it depends, but it depends. So it depends on how complicated it is, and it depends on how many people are involved, and it depends on whether anybody's contesting it. So let me give you kind of the easiest situation. If you have a will and your estate is worth less than $50,000, there's actually a special program for people with small estates called Small Estate Administration, where it's a really truncated, shortened process. The filing fees for small estates is $1, so it's also a cheaper process. And from filing to being done with it, and this is not during now. Right now, the Surrogates Court is effectively closed. It's going to start opening up for business in New York City next week, but it's been closed for 3 months now, and they're backed up because of that. And a lot of people have passed away, right? And so there's going to be a lot of estates being submitted for administration and probate. And so I think that now it's completely impossible to predict how long things will take, but pre-COVID, a small estate administration would take, I don't know, a month or two to work its way through the process if you're lucky. For somebody who they have to notify relatives could then waive appearances and reading. If they don't waive it and they choose to contest the will, that could take years to go through probate. So it really depends on the complexity, how people are cooperating with each other, how much is in the estate. So on the low end, a couple of months; on the high end, decades.
Great. I'm going to unmute people who've called in by phone.
Okay.
Let's see. All right. Anyone else want to ask a question? Whether you're in by phone or by computer, you can unmute yourself if you're using Zoom.
No.
I guess I'd like to just ask a question because, the Cooper Square Committee is affiliated with our Mutual Housing Association, and they have a pretty significant number of seniors in they're like 21 buildings. They probably have close to 100 seniors living in their apartments, and many of them own shares in a very limited equity co-op. So in monetary terms, it's not worth a lot, but it is something that could be passed on to another family member. And many of them, I'm concerned that many of them don't have wills. So I'm wondering if there's a way of sort of being able to bring many of them into Vols to get assistance with preparing them. So I don't know what your capacity is for dealing with that, but we're trying to get a handle on how many don't have wills.
Right. And you know, Carmen should speak to this. We've come in-house and done clinics in the past and done presentations in the past. You know, right now we're not going in anywhere. And it's unclear when we're going to be going in. But we're more than happy to work with Carmen and other, you know, employees of Cooper Square and also the people directly in taking referrals and intakes. And so I could email you, Steve and Daniel and Carmen, our forms to distribute to people and make available to them, and also our flyer to post in lobbies or distribute otherwise about how people can get in touch with us. But we're doing it all remotely right now, and we'll be certainly through the summer and maybe longer.
And speaking of those forms,
yeah.
Carmen, who's periodically in the office, says that we've got some in the office, some of the physical forms as well.
Great. And she probably has some outdated ones because we've redone it during the pandemic, and so I'll make sure you all have the updated ones. But yeah, I mean, people should reach out to us, and if they need somebody's assistance in reaching out to us, they should do that too. We are open for business and happy to help as many people as we can have capacity.
Great. And I've got a question. Someone from the MHA is asking if the MHA could talk about how they handle co-op property of the deceased. So I don't know if anyone from MHA or from Cooper Square Committee could speak to that, how the MHA handles co-ops when people die.
I think part of the problem that we're having is that many of our residents don't have a will or any sort of end-of-life documents. So it makes it a little harder for the MHA to regain possession of the apartment, because that means that we have to go through probate court and figure out if there are any living relatives, because we also don't have information from residents about next of kin or emergency contacts. So it makes it a little complicated for us to regain possession of an apartment if there are no end of life documents, which is why this is so important.
Exactly.
Yeah, I'm wondering what do the MHA's bylaws say about succession rights? Does the person have to be living in the apartment, or if it's a family member who's income eligible but is not currently living there, are they allowed to potentially take over possession?
They have to be income eligible. They don't have to live in the apartment, but they do have to be immediate family members.
Right. Well, I could see that getting complicated if they have several children and a couple of them who live separately in different places are both interested in the apartment. And if there's no will, it becomes messy.
It's very complicated. Yeah.
Right.
I actually do have another question though. If for example, a resident wants to create a will where it only defines what they want to be done with the apartment and not the rest of their property, could that be something that someone can do?
Theoretically, yes. And so if there is something that is not contemplated in a will, then the intestacy statute will apply to it. You know, the way we write wills is you don't have to say this book is to that person, that book to that person. You could just kind of either give your executor the ability to distribute as they see fit, or more often there's a clause that says the residual of the estate goes to this person, which is kind of like the catch-all bucket at the end, right? And so if I don't say my shares go to that, so to a specific person, then it's whoever's named in the residual of the estate who gets those shares. So it would be odd to have a will that just says, I'm leaving this, you know, my shares of my co-op to, you know, to Daniel, and then be silent on everything else. You know, if it was properly executed, I think it would hold water in court. And so I wouldn't write a will that way, but I think it's possible. And just to speak on something that you said before, as far as going to probate court as the landlord, right, or the management company. This happens all the time, not just in co-ops and Michelamas and limited equities. It happens with landlord-tenant relationships as well, because in order to recover an apartment, you can't, engage in self-help, right? You have to go through the court process. And who do you sue? Well, you can't sue the person because they're dead. You can't sue a dead person. And so you have to sue their estate. And if nobody has gone to court to create the estate, then that's a prerequisite for suing the estate. So then the landlord or the management company or whoever has to go to Surrogates Court and create the estate so they could sue them to get possession of the apartment. Which, not, and look, I was a tenant's attorney for 17 years. I'm clearly on the tenant side of things, but we got problems in New York City as far as affordable housing. And we want to make sure that if there's a unit that's available because somebody has passed away, that somebody else who needs that unit is able to access that, to be able to get that housing. Especially if a member of the family isn't gunning for it and wanting to take over, there's waiting lists that are years, if not decades long for these units. And we want to make sure that these things free up so the next person in need can take advantage of that and have affordable housing in our really expensive city.
The other thing is too, would it be possible for people that don't have family members, and we have a large population that don't have family members that are close to them, or anyone that they would feel comfortable leaving their estate to, would it be possible to name, for example, the MHA, to just give the shares back to the MHA?
Certainly. I mean, you could say I'm relinquishing my shares in the will. The other thing is they're leaving it to somebody who's not eligible. There's still some equity there, right? And I don't know what your shares are worth, but $500, $1,000, $5,000, whatever it is, it's a little bit of something, right? So they could leave somebody their shares who clearly doesn't have succession rights. That person, relinquishes the shares, gets a little bit of equity out of it, and then you guys could move on with, refilling the unit. So that's how I would set it up as their attorney.
Thank you.
And you could specify actually in a will that I am leaving you my shares to sell, right? And a lot of people do that where they don't want to see like siblings fight over a house or something, where you say, I am leaving my house to my 2 children to sell, not to occupy. And they could take the profits from that. So that's actually would be the way I would set it up.
We've got some more questions. Someone has asked if Peter, if you have any tips for artists who have a massive amount of paintings.
I mean, I guess, like, do I name the paintings one by one? Do I, let the executor distribute as they wish? Those are complicated things. There's also, intellectual property and, trademark and those kind of considerations in there as well, because it's not just the painting itself, but it's also potentially the rights to license that image to others. So you're not selling the particular physical painting, but you're selling the image of the painting. So I guess my tip is to talk to a lawyer, especially if you're eligible for our services, just to think about those considerations. And, I'm assuming it's not, we don't have Picasso on the line, but, they still have value.
Right. Someone's asked if immediate family includes nephews, nieces, and grandchildren.
I guess my answer to that is for what purposes?
Yeah, I'm not the person who wrote that. If you want, you can write what that was in reference to. Speaking of eligible for your services, is there a specific income threshold that you can share for
Sure.
eligibility?
So what we generally say is people who are at or below 200% of the federal poverty level, which for a single individual is roughly $25,000 a year in income.
The 200% is 25,000 right now.
Correct. So 100% is 12,500 roughly. So if you're at or below $25,000 a year in income and you're a single person living alone, then you're clearly eligible. We also look at assets too. So if you make $25,000 a year, but you've been a really great saver and you have $4 million in the bank, we're not going to be able to serve you. So we balance both of those things.
Is there an asset threshold, or is it
anywhere from $50,000 to $100,000 in savings? A little bit depends on the kind of asset. There's certain IRAs that aren't accessible without penalty that we won't count. And so if you're close, talk to us, because we make exceptions to this all the time. A little bit is about how many volunteer attorneys that we have, but also we look at, do you have high out-of-pocket expenses? People who have really high rents, people who have really high out-of-pocket medical expenses or expenses related to personal care. So we will look at those factors. And for people who are veterans, we double those numbers. So if you're somebody who served in the military, we look at 400% of the federal poverty level because of the funding that we have for that work.
The question about immediate family was in reference to succession rights of a Cooper Square MHA co-op. If
I will
immediate
let
family
the
includes
MHA
nephews, nieces,
answer the
grandchildren.
question. I don't know. Vanya?
Sorry, I had to unmute. I would, it's definitely in the bylaws, so I would have to double check what they define as immediate family members. If you'd like, you could email me and I can let you know exactly what that means.
Yeah, we get a fair number of questions all the time about MHA things, and we often say check the bylaws because they answer so many questions.
Mm-hmm.
Yeah, I could send you a copy of exactly where that's listed as well.
All right. And I'll just remind anyone, a couple new people joined us. You're welcome to unmute at some point if you want and ask the question, or type into the chat what your question is, and I'll relay it to Peter. Another question, does income from Social Security count as income?
Yes. That's most of our clients' income is Social Security and VA benefits and that kind of stuff.
I have a question, if you don't have another one lined up.
One other question is, if someone comes to VOLS and is not income eligible, does VOLS make referrals to low-cost lawyers?
We will provide you counsel and we will give you a list of lawyers. We don't make referrals. As a nonprofit, we're not allowed to make referrals. We just provide you resources. I know I'm splitting hairs, but I'm a lawyer. It's my job.
Indeed.
And low cost is a relative term. So I think other than us free lawyers, no lawyers are necessarily low cost. So depends on what your threshold is, what your tolerance is.
Gotcha. I wanted to ask before, Steve, we get to your question. For anyone who is joining us by phone or is unable to see the screen you're sharing, do you want to read out the information for how to contact VOLS?
Sure. So really the main thing, assuming you have internet access, then the main thing is just to go to our website, which is volsprobono.org. So VOLSPROBONO.org. And all the information you need as far as phone numbers and how to contact us and our intake forms, they're all on our website. Just click on the Elderly Project tab. Or if you're a veteran, click on the Veterans Project tab. If you don't have internet access, I'm going to give you a phone number, which is for our staff attorney, Alyssa Villarreal. And her number, and I'll read it slow, get your pens ready. It's 347-521-5709. So again, Alyssa Villarreal, our staff attorney in our elderly project, and her number is 347-521-5709. If you're a veteran and you want assistance, you should call our Veterans Project attorney. Her name is Jess Penkoff, and her number is 347-521-5725. Again, 347-521-5725.
And what are the hours to reach people by phone?
9 to 5, roughly. But pandemic hours also.
Indeed. Steve, what were you going to ask?
Okay, so assuming someone has prepared a will and they've done it properly, and they've named someone as a friend or relative as the executor, would that person be able to go to surrogate court to probate it without an attorney? Is it something that can be done pro se, or do you think they should have an attorney?
I think, depending on the complexity of the estate, that they can and they should do it pro se. One of the things that they might find in trying to do that is the clerk might say to them, you really should have an attorney. And, and we encounter this a lot. And my stock answer for everybody is there's not a single kind of court proceeding in the United States of America where you have to have an attorney. There's no law that says you have to have an attorney. You're entitled to represent yourself. And that's a tool that's used to exclude low-income people from accessing the courts. And so they should not be discouraged. And if it's a fairly simple estate, then it's something that they can navigate on their own. Us lawyers like to think we're smart, but it's not rocket science.
Right. So just taking that same example though, but in this case, what if the person prepared the will themselves, they used LegalZoom or something, and then they didn't get it notarized or something, but they have a witness maybe, but it doesn't fully meet the requirements for a properly executed will, and then the person goes to execute it, the executor, then what, in that situation, would you recommend they should have an attorney, or what should they do?
I guess it depends on how close the will is to being right. Because if it's close and there's a case to be made that the court should liberally construe and honor the will, then I think it's effective to have an attorney. But if it's like completely not even close, then why waste your money? Because the best attorney in the world is not going to be able to accomplish the impossible, right? So, I mean, you mentioned notarization. Wills don't have to be notarized, actually. They just need to be witnessed by two people who, are not named in the will. They're not interested parties. They, have to do it within certain time frames. There's, rules. And so, it just depends on how close it is, right? And they can certainly try on their own if they're getting some pushback, then maybe that's the point at which to hire an attorney, or at least get a legal consultation with somebody.
Okay.
Peter, can you say, can you describe just generally how this self-notarization process works that you mentioned that people can do these days during the pandemic?
Right. So virtual notarization.
Right.
And virtual witnessing. So there's a couple of executive orders that the governor has issued that temporarily allows for virtual witnessing and virtual notarization. Normally the laws are that you have to be physically present before somebody to get your signature notarized or to witness them signing. And it's not just wills, it's powers of, it's all these documents and more that are included in this. And so this now temporarily, and I think the most recent extension allows it through July 6th, I think is now the end date. And it's been extended a number of times. The governor's only allowed to do it in 30-day increments. So depending on how reopening goes, it might end, it might get continued. But you need to be able to have a live video chat. So you could see the person signing their will. Then and just using the will as an example and witnessing as an example. Then what the person who has signed their will needs to do is scan in some way, whether it's fax or, you know, scanner or using your phone and like a scanner app, take a scan of that document that you've just signed, transmit it to the witnesses the same day that you've signed it. So they need to live watch you sign it, then you transmit it to the witnesses the same day. The witnesses then can print it out and sign it themselves, saying that they witnessed you signing your will virtually. And then they could send it back to you. They don't need to email it or scan it back. They could put it in the regular mail or hand deliver it. I don't know why you would do that if you could just be in the same place. And so that's how it works. Notarization is a little different because with notarization, then you have to show an ID to the notary. For the notary, you have to be physically present in the state of New York in order to take advantage of that. So people who've left the state can't use virtual notarization, even if the notary's in New York. And for notarization, the entire document needs to be transmitted to the notary, not just the signature page. For witnessing, the signature page is sufficient, but for notarization, it's the entire document. And you know, our powers of attorney are, when they're short, they're 7 pages long. Wills are often as long as that. And so, you know, if you got a scanner with a feeder on top, that's easy, but how many people have those at home? Usually we're looking at, you know, using our phone and taking pictures.
Great. Someone has asked, where can they get the form for a will?
There is no form for a will. So, you know, like I said earlier, there's certainly online services, but wills are very individualized.
I have a question.
Yeah.
So,
Steve?
assuming someone does want to come to Vols to get a will done, what do you recommend they do in preparation? Like, should they have written down basically everything that they, you know, the people that they want to bequeath different things to, so that, you know, so that they're not consuming a lot of the lawyer's time, but just really how much preparation should they be doing?
Well, look, when you reach out to us, you know, we're going to get your basic information, and then we're going to give you our questionnaire, which is going to go through each of these documents one by one and ask exactly those questions.
Okay.
And so you don't necessarily have to do it in advance. I mean, it's nice when you think about it, but when you sit down with one of us or get on the phone with one of us for the first time, we don't want to hear all those answers. We want you to get our questionnaire and fill it out and send it back to us. Because, you know, some people who don't have access to technology and have challenges will do the intake questionnaire over the phone. It takes anywhere from an hour to an hour and a half. And so we try to streamline that by getting people to fill it out on paper.
All right.
Great. I think we've got about 5 minutes left. So if anybody, we've gone through all of our questions. If anyone's got any more questions, let us know either in the chat or you can unmute yourself.
Okay. No more questions?
I think so.
All right. Well, I want to thank you very much, Peter, for coming today and doing this presentation for us. I think it's been really helpful. And we'll talk to the residents and follow up and try to refer some people to you.
Okay, great. Well, it was a pleasure doing it. Thank you all for the time, and everybody be well and stay safe, okay?
All right. You too.
All right. Take
Great.
care.
Thanks, Peter. Peter's put up the info to contact Vols, and if you have any questions for Cooper Square, you can contact us through a few ways. You can email csc@coopersquare.org. You can also leave a message at our main phone number at 212-228-8210. Thanks for joining us.
All right. Thanks, everybody. Take care.